Hi everyone, welcome to an hour with LawSikho. Today we have with us Shruti Priya, who has been a lawyer in the technology industry, IT industry for a while now, and she is going to tell us a lot about working with the government sector with respect to information technology and all the interesting experiences she had as a lawyer, and of course a lot of career guidance and the opportunities that are coming up in these areas. Welcome, Shruti.
Hi, Ramanuj. Thank you so much.
Hi. So, would you like to introduce yourself and tell us about your background so far, so that when we ask you more questions and you share your wisdom and other stories, people will know where it is coming from.
Great, definitely. I don't know about wisdom, but definitely I'll share my journey till now. So I hail from a very small city in Jharkhand, Ranchi. And, my father is from Bihar and mother is from Nepal. So growing up in a household full of doctors and engineers, it was a really, weird thing when I went to my parents and told I want to be a lawyer. So, nonetheless, they kind of accepted it. I finished my law degree from CMR Law College, Bangalore in 2010. And as it happens with most of the, freshers, I started at a law firm, which gave me a good experience on understanding the nitty-gritties with respect to general corporate or be it litigation matters or even day-to-day admin work, right from the filing and how you have to process, what kind of stamp duty you have to pay, etc. After working in law firm for almost about 3 years, I took a conscious decision to move in-house. And thankfully, I was working with a client who also happened to be an ex-HP, director. And I just started checking with them, like, how it is to work in-house and what's the work atmosphere, what's the work that you get. And, I applied in HP and got through it. And that was a breakthrough for me because I realized I flourish as an in-house counsel. I got to learn a lot working at HP. Worked there for 5 years, first as a legal counsel for India, and then went ahead to join the APAC team as a region counsel. And I also moved to Kuala Lumpur and then was supporting APAC region, especially Malaysia, Indonesia, and Singapore transactions. So this has been my journey as an in-house counsel. After that, I moved to Amazon for a brief period, and now I'm back to India as a senior legal counsel for Truecaller. I'm sure you have heard about this app, and it's an interesting time.
Even
Yes.
today, I read about Truecaller in the news and about the chiller acquisition and some issues with how the government is planning the NPIC, I believe, National Payment Corporation
Yeah.
of India. Yeah. So they
Yes.
stated below a certain threshold of of transactions per day or per month they are going to discontinue or something. And I think there were mentions about Truecaller in the same article.
Yes, yes. Actually, it's a little different it's true that NPCI has, issued a notice, but it's more towards the payment gateway app. It doesn't only affect Truecaller, but most of the payment gateway app that you have in the market, right, from WhatsApp, Paytm, PayPal, etc. It's more to do with data localization and ensure that there is no illegal activities or money laundering or any kind of fraud threats. So as I was telling, right, I mean, it's an interesting time to join a company like Truecaller because it's not only about these new circulars and interacting with the regulators on a day-to-day basis, but also when you have GDPR coming into picture, people are becoming really aware about privacy rights, data protection, etc. I mean, how do you actually educate people, and how do you carve out your contracts, and legal documentation is also important. So this has been my journey so far, and yes, I'm enjoying it, and hopefully it will go even better.
Absolutely. So you are right at this point. You're an in-house technology lawyer, right?
Yes.
I mean, that is how we can I know that technology lawyers do not deal only with technology. Of course, they have to deal with everything else as well. It's not that you are doing only working on technology law. But when you were an in-house lawyer specializing in technology companies for a while, then what sort of work do you do?
Look, I mean, as you rightly mentioned, Ramanuj, right? See, I know you can call yourself a technology lawyer or, or whatever nomenclature you want to give, but the moment you are an in-house lawyer, you end up doing almost anything and everything, right? There are days, for example, when chiller acquisition happened, I have been supporting on terms of employment transfer, the post acquisition formalities. I think it kind of entails of everything. However, if you want to consciously develop your career in technology law, it is important that you first understand that what part of technology really attracts you, because there are various sectors, right? There is this banking sector, banking and financial sector. Then you have these core solutions which is developed by IT companies. Then you have these data center setups, etc. Then you have nowadays, for example, AWS, where I was working, Amazon Web Services. It's like completely cloud services oriented, right? So first we need to understand what part of technology actually attracts you, and then probably you need to build up your resume or start your research or your groundwork to understand how you can apply, narrow down to some of these companies and how you can apply to these companies. And of course, it also means that you read up on the day-to-day regulations which is issued, understand how the basic work, right? It's not only about understanding how the contract needs to be drafted, or the fact that how you have to interpret a certain law. It also means that you understand how this particular solution works. You have to sit with your stakeholders, be it for the finance person, be it the solution guy, and understand what that company is actually doing, like, from A to Z. And then I think, you would be in a better position to call yourself a technology lawyer, because then you understand the solution completely and then accordingly draft the definitive documents or advise them on the legal aspects of it, right? Right from your contractual, IP related, data privacy, competition law, etc.
Got it. So, I'm going to ask you very soon a little more about that and about what lawyers need to learn and do, and even about young lawyers when they want to work as a technology lawyer, how they can build their career up. But before that, I wanted to know, what kind of work would who's a a counsel, in in-house counsel in a technology company? What sort of work do you do? You have seen a few companies, so what sort of work comes on your table?
Okay, so Ramanuj, every company has a different structure. So to start with, let me give an example of HP, for example. When I started, HP was, one company wherein, you had the product and enterprise team both intact in one entity. Yes, at the same year that I had joined, 2013, HP announced that they will be separating their product and enterprise service business. And then the enterprise services segment of it went ahead to merge with Computer Science Corporation in 2016-17, and now it is known as DXC Technologies. So, as I was mentioning, that every company has a different setup, and hence your work might be different. Day-to-day work will be different depending on the team that you are part of. So, to tell you more about HP, for example, my stint there started as a counsel, wherein I was supporting mostly the India deals, where if you have RFP, request for proposals, or any private or public tenders that is issued, I have to review them, and then work with the different stakeholders, and then provide a risk assessment. And based on that, once we are down selected by that particular entity or that government entity, then we go ahead to negotiate the contract. But then, as and when I grew in the company, I also like had a different division of it. So apart from my day-to-day transactional work, I also had to advise on any general legal matter, which would range from any existing account disputes, right? Where we might have existing account and you have either a payment related dispute or not being able to meet the service levels that we have committed for, or just doing a general risk assessment of those documents. To also be involved in any IP related matters, which would mean also advice on any branding guidelines that we are floating ahead, and then also be part of pro bono. This was the culture in HP. This was like a day to day life of a legal counsel, in house legal counsel looked in HP. But then when I moved to Amazon, it was slightly different in terms that the principles was different. The team that you were part of, or the structure of the team, was pretty different. Here, the basic work will be, of course, similar, wherein you are dealing with commercial contracts. You are at the end of it. Your majority of the time at the end of it is going and negotiating or liaising with the government customers. But also, as part of different projects, you probably will be doing more analysis on a competition law across the APAC countries. Similarly, advising to the senior leadership team more often, or attending these meetings. And now, if I have to come to Truecaller, it's a complete different environment, because we are a very lean team in terms of the legal members that we have. And I have to support not only India, but also some bit of Sweden, and we have just started on Africa as well. And here, my day-to-day life, or the job profile of a legal counsel, it consists of anything and everything. There are some days where people have come to me and asked that how do we file this particular form with the ROC, which is Ministry of Corporate Affairs. And then there are days where I have to draft a term sheet and provide what term sheet in terms of a prospective acquisition. Or there are days when the GDPR was floated, we also had to update all our privacy policies, terms of service, and then update them on the online portals. And then, of course, liaising with other law firms. So, as I mentioned, it does differ from company to company. Also, the fact that which team are you part of, and also how would you want to shape up, and what kind of projects are you handling at that moment. I hope that does answer your question.
Yes, it does. And I mean, we got a very clear picture of the sort of work that in house lawyers do in technology companies. Can you tell me, like, now I would like to ask you, let's say if I am a young lawyer or a student, and like this is a quite a common question we get from many of our students in LawSikho. They come and say that, I want to work in the technology sector. I'm interested in technology law, and I would like to grow myself into that career. So that's so basically, I want to ask you at this point, uh, like unlike maybe when we were in law school, now students start thinking about it pretty early what they're going to do, and maybe it is also justified given a very competitive uh, scenario in terms of where what people want to do, where people plan things really early. uh, so what could one do to start developing themselves in, to prepare for a role like this, and how, like, what could their way into the world of technology as a lawyer?
Yeah, it's a very good question, and I think yes, during your law college days, you have to understand which is the field that you want to pursue. And that can only happen by way of diverse internships that you can do. Unfortunately, during my time, there was not this, I mean, at least I was not exposed to this much of education where I would understand, okay, this is the technology law that I can pursue, or this is the media law that I can pursue. At that time, it was, like, oh, we all want to be corporate lawyers, and what do you do for that? So you do internships in law firm, and then really work hard to get a PPO from, in the law firm, so that you don't have to worry about placements. But then, yeah, times have changed now. In fact, in HP, I was also helping out with the internship program that we came up with, and the kind of juniors or legal interns that we got on board, it was not only really interesting to work with, but there's so much to learn from them, because it's become quite competitive these days. And one of the good things I liked about these young legal interns was that they're very clear in their head from the time that they joined HP, or whatever brief period, like 2 months or 3 months internship that they did at our company, is that they wanted to shape up their career in in-house. If not, at least they wanted that experience to analyze which which side do they want to go. Do they want to become a in-house lawyer, or do they want to become a associate and go down the ladder of partner and managing partner? So to 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 become a technology lawyer, the first thing that you need to do is start with internships. Do various kinds of internships. In fact, these days, kids start doing internship from from +2. I've seen you don't even have to wait till you get into a law college. There are these research assignments, and there are multiple programs which is either floated on LinkedIn or in public domain. Companies like Google, Amazon, HP, they keep floating these programs. Just keep an eye out for these programs, and start, either be as a research assistant or be a summer intern. You can just start there. And once you have once you start doing it, you kind of understand that is this your forte or not. Are you cut out for this particular job or not? Would you want to pursue this further? And that's when you start spending some serious time towards it. So if today, if you ask me if I'm in a law college, or probably in +2, and I know that I want to become a technology lawyer, or a lawyer some few years down the line, I would first start with these internships. Then, towards the third and fourth year, I would take some serious internships in these companies, build up some network and connections, understand whether I like this work or not. Also, understand the kind of companies, as I mentioned earlier, that you are applying for or are trying to get in, because it's very important that you understand their business model. um, and unless you don't if you understand the business model, you would know what is required, and accordingly prep yourself, be it with compliance related issues, or competition, any kind of project that you can undertake, and show your talent or skills. And after that, yes, there are various ways to connect these days. If you have interned in one of these MNCs, you will definitely establish connections. Once you pass out, please start floating your resume. Otherwise, also you have LinkedIn, etc., available on, in today's world. You can always reach out to one of the senior members or one of the company in-house lawyers, and I have realized they're extremely cooperative to guide you. So then, you should make use of these exposure that is available in today's world, and start applying for these places. In terms of academic understanding, I think, of course, keep yourself abreast with the recent IT, information technology law, or any amendment that comes across. Do read up these articles. There are various ways you can actually subscribe for so many news which keep coming on, or regulatory portals where you can subscribe for, and you get these updates. Apart from that, also also try to ensure that you have a defined set of, how would you want to with whom would you want to interview, and how would you want to process it further, because these days it's become quite quite exhaustive in terms like you don't have just 2 or 3 rounds of interviews. You also have now you have telephonic rounds, and of course you have a discussion, and then they want to see your written skill. So be prepared for written tests or written assignments as well. You can expect some agreements which they will ask you to review, or they can give you a research assignment and ask you to prepare an opinion or provide your views on it. So I think these are the various permutation combinations, and if one is clear in their head that this is, they want to become a technology lawyer, they can pursue all these steps.
Okay. So, for us, we frequently we have courses which are on or which are around technology law, and we have students. So, I want to take this opportunity to ask you also, like, what we could possibly teach. So, usually, for these programs, we believe that our approach is that there has to be obviously a certain amount of knowledge that you should learn about the various technology laws. And in case of technology law, learning only perhaps Indian law is sometimes not adequate. You sometimes have to understand global perspectives of what is happening around the world in terms of financial technologies, regulations, uh, even in terms of different technologies and how they are getting regulated, from data protection to everything else. So we focus on one part is the knowledge, but we focus a lot on getting students to write articles, publish them, and also work on their CV from that perspective, and also start finding mentors in that domain. So where they can actually connect with maybe somebody working in a TMT team in a law firm, or could be in-house counsels. You find mentors and you start connecting with them and getting their feedback on what you should be learning, and how you can progress in that career. What in terms of academics though, what do you think are the, say, let's say the if you want to bring more practical approach to training, what could be some of the things you can teach to take students who want to be good technology lawyers?
Okay, so first and foremost, it has to start with contract, because if you want to be a technology lawyer, there are, you will have to invariably do a lot of IT contracts review, drafting, etc. So, in fact, to be any kind of lawyer, I think the basic is essentials of contract. So you need to understand how the contract law works. What are the key boilerplate clauses which you should ensure that is covered in a contract? So that's one of the first subject or training that I would advise. The second aspect of it is, as you rightly mentioned, that it's not only enough to understand Indian law, because in today's world we do get affected by other laws as well, which any other global law which comes into effect. To give you a
Yeah,
very good
most
example
technology
of
companies are global in nature. At least if they are, like, most technology companies are global in nature. They have a global business, which is
yes. Yes. So, as I mentioned, a contract law, most of the common law countries, it doesn't change. So, essentials of contract usually remain same, and those clauses won't change. Maybe the drafting style and sometimes, a certain aspect of it might change. So, you have to do the research and understand the applicability in that particular jurisdiction.
there may be some disclaimer or something in certain jurisdictions which you are supposed to put in contracts, like disclaimer of liability and stuff like that, which is kind of mandatory in some.
Yes, I mean, liability disclaimer is something that I would advise in most of the contracts, especially if you're advising your own company and you're procuring something. But yes, it does differ from country to country, because in aspects that, for example, when you're giving a liability limitation of liability disclaimer and indirect and consequential damages, disclaimer is quite important for India, but in other common law countries, it might not hold the same importance or relevance. So yes, I mean, it will depend based on the jurisdiction. Coming to, as you mentioned, right, that yes, most of these MNCs have a global presence, and usually they are categorized on a region basis. So it is important that you not only understand the local law, like Indian laws, but also the particular region or let's say it's a US global MNC, then also what is the key laws that might affect that particular company. For instance, when I joined Truecaller, and I think most of the companies in India and abroad are affected by GDPR, General Data Protection Rules, as of now, and you would have received so many privacy update notifications. So it is important when you have these kind of global, law changes or reforms, then the students have to update themselves and also understand the impact of these laws in their respective countries. So, for example, I know GDPR is an European law. A lot of companies are getting affected there. Uh, However, in India, we don't have a specific privacy rules per se. The bill is still under consideration, but Information Technology Act does provide aspects of it, privacy law. But then the time is not very far where we will have a new data protection and privacy rule in India. In fact, there has been multiple conferences which I recently saw going across either on LinkedIn or otherwise on emails. How GDPR might impact India and what are the things that you should be conscious of while trying to be compliant with this GDPR regulations. So understand the impact of these global law, which is floated from time to time. Advise your company. In fact, the best way would be, as you mentioned, to write a piece of article on these new regulatory changes, and also analyze how it can impact the Indian companies. What are the key steps that the companies can take to become, for example, GDPR compliant. I remember someone just walked up and say like, oh, now what will happen? GDPR has come into force. Now we just need to take XYZ consent. But then there needs to be an education that okay, where is the GDPR applicable? And since your company is an Indian company, for instance, what is the extent till where you have to apply with GDPR? You may not even be required to do those XYZ things because it's not applicable completely in your jurisdiction. So that's one example. Second thing I would say is apart from contract and the general regulatory updates, also understand employment law bit, because this will be a good curriculum to have, because most of these MNCs have a lot of employees and they do handle with these employment issues internally. So to understand, what are the maternity law benefits, what are the kind of leaves that you can provide in particular state. It does differ from state to state. What are the working hours? What are the rights under our Indian regulations? Industrial dispute regulations. What are the various for example, these sexual harassment policies or various kind of policies that you can draft or apprise the new employers with, or you can help your employees with. So
So
this
I
would
think
be
compliance would be a major area, right? Like compliance to
yes.
generally.
Yes, compliance. But yes, so most of the time, what I've seen is that compliance, you will have a team who is assigned, right? As an in house lawyer, you, of course, will have to look over the compliance bit, but it is important that you apprise yourself or ensure that you're very well versed in these set of laws, for example, contract, data privacy, competition law, IPR, employment law, because you will face day-to-day nuances which deal with these particular laws. So to have a curriculum which deals in these areas would be great.
Okay. That's very good to hear because we cover most of these things. But do you think that like when we like one big issue that we see regularly when students are studying law is that they are they are studying the sections and they are studying some case laws. This is how mostly in India law is taught, and this, I think, there's a major disconnect in terms of like if you study contract act, you still do not know how to draft contracts. If you study GDPR, you may not understand how to create a GDPR policy. Or if you study the Sexual Harassment Act, you may not know, how to firstly create a policy, second how to implement it. Even if there's a hearing, during a sexual, there's a complaint and it is being further processed, and there's a hearing. How do you conduct it? How do you collect the evidence? So there are a lot of gaps that remain in terms of what you study and what you actually have to do, which people are very. I don't think when you go to the internship you really get to learn. In that anybody has time to teach you things to at this level. So, how do you think that lawyers can make an effort to learn more on the practical aspects? Of course, we cover these things in our courses, but I'm just generally asking for somebody who's looking to. Um, I'm sure when an interview happens, if you are sitting across the table, you would always prefer somebody who has more understanding of how to do the job rather than just a theoretical legal understanding of the subject. But how could lawyers work develop these things? If you have any suggestions on that.
Yeah, thanks, Ramaj. I think this is a very good question in terms that we really need to address this and probably change our education system in colleges, law colleges. I know national law schools probably do it to a certain extent through various academic projects and curriculums. But I think we need to inoculate ourselves, against this kind of a teaching method. Where you're learning, you're trying to learn the sections and case law. I still remember Minerva Mills. And you know how many times you would have tried written that case law and the findings of that case law, which hasn't come even once in my entire career as a lawyer I've worked. So yes, it is important that we have more of a practical view towards educating ourselves while in law college, as compared to only doing theories. um, One of the most important thing would be to understand, if you want to be especially in-house lawyer, to understand how you can succinctly put across the issues, identify issues. Because, no offense to law firm or, any, and like, they're high, most of the associates, senior associates, partners are highly educated, and their drafting is of supreme level. But I have seen this as a part of in-house lawyer. There are times where the legal opinion, these law firm legal opinion, have gone to the senior management, and they're like, "We can't read this. We don't have time to understand this." Right? You need to break it down, understand the background, put forth what are the issues, and to the point you have to tell or recommend to the management that, what, this is XYZ which we can do, these are ABCD which we cannot do, or if you really want to do, then this is the risk that may entail, or these are the mitigations that you can consider. So one of the most important thing that we don't learn in law college is to identify issues in a crisp manner, then be able to succinctly put across these issues and form recommendations for them. You can definitely give references of the sections of the particular law, but at the end of it, when you are advising a business team on a transaction, what they want to hear is what they can do and what they cannot do. So this would be my advice.
How to do something. How to do is also important. Like if I can do something, then how do I do it? And that
Yes.
also.
Yes, absolutely. Like, what are the step one, step two, step three? And again, there they just want to understand in a very concise manner that these are the steps that I need to follow, rather than going through a lot of documentations and and then understand, okay, these are the sections which will regulate these aspects. They are not interested in those things. So, it is important. I'm not saying these are not important things, but my advice is that apart from our theoretical studies, or our traditional study that curriculum that we have in colleges, we should also try to inculcate a behavior where students are given regular assignments where you have to, identify issues and then accordingly break down and come up with steps how to do it, or mitigations, or recommendations.
Great. Even we try to do that to our, that's like our, in our courses. What we do is that we give people some material to read and videos to watch, which is their study material. After that, the main uh, part of the course is that every week we give them two exercises in all of our, long-term courses. So what they have to do in the exercise could be like, just to give you a random example. Let's say if it is merger and acquisition, let's say we say that, okay, maybe Paytm is being acquired by Google. Okay, now you have to prepare the uh, maybe the shareholder agreement. Like, this is a proposed shareholder agreement, and from your side, what changes will you make? Or this could, or it could be anything. It could be that, okay, this is a agreement you have received. Now prepare a negotiation strategy. Like, what would you negotiate? What would you not negotiate? What would be your ask list? And prepare that. And then we discuss that in the class. So this is the approach we usually take to teaching anything. And we technology contracts is something. This is how, like, starting from, maybe we'll say that, look at this terms and conditions of Amazon Prime. This is actually a real exercise we have, that look at the terms and conditions of Amazon Prime, Netflix, and Hotstar, and now compare these and see what are the differences in these terms of agreements, and come up with a paper that then there's a discussion around that in the class. And none of the classes are actually lecture based. They are usually this kind of, we have doubt clearing classes, but besides that, for every class we have these kind of exercises. And it's quite interesting way of learning the law also, I think, because a lot of time people have a huge problem in remembering the law, because you read a section and you don't understand how this is going to ever apply to anything. And it's like a very dry exercise where you're trying to remember facts, you're trying to remember some rules, you're trying to remember some case law. But when you actually do an exercise like this, I see that lawyers and law students are able to remember it better. Like, it's a more experiential sort of learning. So what do you think? Like, do you think this kind of training would help to people to become better lawyers?
Ramanuj, what's the first thought that comes to my mind after hearing this is that I wish I had this kind of a curriculum while I was a law student. Instead of spending my 3-4 years of the career in the beginning to understand these nitty gritties, I would have been well prepared even before jumping into the work segment or the corporate sector. So I think it's a brilliant approach and strategy towards making law students understand theory versus practical, and rather than just trying to mug up sections, or just understand just read those particular laws. It's more towards applicability of these laws. In fact, you won't believe the exercise that you're providing, wherein you mentioned that compare the terms and conditions of these XYZ companies. That's an exercise, or that's actually a work assignment that we are required to do as in-house counsels.
Oh,
Because
really? Okay.
yes, because many a times when you're coming up with a new kind of a product, right, you're trying to launch, so you would want to understand, that have you covered yourself in terms of, cover yourself in terms of all the required clauses. Many a times it might not be a pure legal clause, it might be a commercial clause, for example, a step in right, or what are the kind of payment terms that they have, or what are the kind of service levels that is being floated in the in the market as of now. So to understand these terms and these kind of terms, there is an analysis which is done. And also, not only this, whenever you pick up a competition law project, we had these projects where we had to analyze competition law in various countries within APJ region, right? Be it Singapore, Malaysia, Indonesia, Philippines, India. And of course, then you take up these case studies as well, like, this particular company is engaging into these kind of activities, or these are the terms and conditions or the process that they follow. So I think they're getting the best of it, if you ask me, from that aspect. On the first part where you said that the curriculum does it, like, let's say there is an acquisition of company A by a company B, and they start with the shareholders agreement. I think it's again a really good part because, uh, you know, not only, like, you're not only sticking to the technology or contract law, but you're also venturing into private equity and other sets of laws and those kind of agreements, which does come in handy. In fact, very recently I had to draft a new term sheet. I did private equity almost about five years now, 5 years back. And I was just trying to read up again on what is the SEBI regulations on particular shares, what are the Companies Act, because it's changed in 2013. So I think it's again a very good exercise where they can start with probably term sheet and shareholders agreement, and of course this will help them in remembering the regulation as well. Because when you have to apply these in drafting a clause, it really helps to remember the particular law, and what is right, or what you can do and what you cannot do. So yes.
Yeah, and I think this is a quite a no-brainer way of teaching. For us, we have been trying to do this for now 7 years on this particular, trying to find the right way of teaching people. And for a long time, we have been giving people things to read. Like, "Look, this is the course material. You read this, and this is the exam you take." And this approach didn't work because we had huge number of dropouts at different points. And when we started calling people and asking them what they said, that yeah, I read it, but people couldn't apply. And I mean that's, I think, a huge area that to work on, and there's a lot to learn from us and create the right exercises. But I want to move on. Unless you want to add something, I want to move on to another area.
Yes, I just have one point to add. I missed, mentioning earlier. You also mentioned negotiation, right? And it's good that these activities are provided as part of the curriculum. One more thing that I would really, recommend is doing these mock negotiations, because that's extremely helpful. When you walk into a room full of non-lawyers, right? Which is mostly the case, especially while I was handling government transactions with government departments. You have highly qualified people, double PhD or IIM, IIT, and IAS officers. They're extremely well educated, right? So to be able to present your case and articulate it in a proper sense and proper manner is extremely important. And that's something that you will learn by doing these mock negotiations, or learning the tricks and trade of negotiations. So that's something that I would just want to add.
All right, thank you so much. So we want to ask you about your experience in the government sector. Like, you have been working for companies which extensively work with the government in the enterprise side business, I believe. So what was the experience like, and how do you deal with the government? What's your story on that?
Okay. I briefly mentioned that, so that, as part of in-house counsel role, I had to review RFPs, which is your basically request for proposals and or tenders that is floated by government departments, and accordingly advise on that. So just taking that forward. So I was handling North and South region for HP India, and for enterprise services segment. And any government RFP floated, would come to me, and I have to review these requested proposals, understand the terms and conditions. When I say terms and conditions, it doesn't only entail legal terms and conditions. You have to first understand the solution that is being proposed, how their entire flow chart works, what comes up after A, what comes after B, and then work with also the stakeholders, as I mentioned in the beginning, which might be right from your finance team leaders to solution to business team, and then prepare an analysis, which has basically, from a company perspective, what are the positions that you can accept, and what are the positions where you would want to seek some changes. And as it happens that we all are aware that it's not easy to work with government sector, just by the sheer fact that there is not much room to negotiate. So, for example, today, if I have to get into a IT outsourcing contract with you, it will be probably a little easier for me because I will explain to you that Ramanuj, these are the clauses. We need a specific indemnity clause. We need a limitation of liability clause, and hence, you need to accept these XYZ changes. It doesn't quite happen in the government sector, because in government sector you are given an RFP. When you go with changes, I have faced situations where the government authority or the authorized representative would have said that, Shruti, you can only make 5 changes in 5 clauses. Now you decide which 5 clauses do you want to change. and and it has to be just like really minimum changes, because the problem is, unfortunately, in India, we are still, though we are progressing, but we still have these hierarchy system, right? So it doesn't happen that one person has the authority to take a call. It goes to first person A, and then again, it has to be approved by 4 or 5 more people on top of him. So it's a cumbersome process in that aspect. So I think working with government, working on these deals with government sector taught me a lot. Right from how to be extremely patient, how to make smart changes in the contract, rather than, I know language or draft is extremely important, but at times you need to be able to articulate or put your draft in a way that you don't make too many changes, but you have covered important or key points. So we used to call it light touch or smart, drafting changes in HB. Apart from that, most important thing is, how do you negotiate with a government customer, right? How do you prepare the use cases and make them understand this is how we can do XYZ thing, and these or there are certain things that we cannot do and why. The other thing also is, working with government customer also teaches you that there are these dispute situations, and how are you able to express your views as a lawyer when you're representing an MNC, which doesn't create any kind of a controversy. You have to be extremely careful as to the statements that you make or the way that you're representing your company, because at the end of it, you are making these representations in front of regulatory authorities.
So,
So
I want to ask a couple of things at this point. I have seen some government contracts. Uh, Particularly, I remember a 300-page contract, and in this 300 pages, I mean, somebody has really put their mind to like coming up with, really horrible clauses for the service provider. And this is a big company, like it's a Fortune 500 company which was providing the services, and it was just, I would say, I mean the company accepted it, but for them, they're in the EPC. It was an EPC contract, and they deal with such contracts regularly. But it was basically a lot of unenforceable clauses in it, which the company knows that these clauses the government is putting on us, but these are unenforceable if it goes to the court. But besides that, mostly, like really terrible business unfriendly clauses, which would, I mean, fantastical clauses. Like I would not even say they are in kind of in the realm of reasonability. And I'm sure you are being polite about what you experienced, but I'm sure you saw similar situations. And as a lawyer, how do you deal with those situations? Like you said it's a light touch and all of that, but when you have 50 such clauses and you can make 5 changes, I mean, how do you deal with it? Because it's also pressure from your company side that you have to sign the right contract. So I'm it's a quite a sandwich situation. I will say that. So what does a lawyer do? I'm not asking for any specific situation, but if you could give like a general idea about.
yes, I think Yeah, Ramanuj, it does happen. I can't deny. In fact, I have been on the receiving end of these 300-pager contracts, which we have to review over a certain period of timeline and revert to them. So, look, what what is the what you need to do in situations like these is, of course, create a list, right? As I was mentioning, there is a lot of work that goes into reviewing such contracts, and you create a list of the clauses which, as you mentioned, certain clauses are unenforceable, even as given the country that we reside in, like given the jurisdiction that we are in. Some clauses are irrelevant, right? And certain clauses are extremely important, wherein you definitely need changes, to call out a few. For example, a open-ended indemnity, absence of limitation of liability clause, a risk purchase or a step-in rights where they will ask you to any XYZ number. Absence of any roles and responsibility clause, which doesn't basically state that these are the roles and responsibility of the vendor and these are the roles and responsibility of the purchaser. Um, it goes, the list goes on, so on and so forth. So the thing is that you need to categorize these clauses, and then, of course, there are internal discussions as to understand which are the clauses that are extremely important to us and the clauses which we can accept. So what we usually do is that prepare a mitigation or analysis report. Now, as I mentioned, some of the clauses which are not going to harm you and your company does have the ability to digest them. A classic example would be a termination for convenience clause. So usually, you wouldn't want to give this right to, to purchaser, that they can terminate the contract at any time without providing you any valid reason. However, given that these are government contracts, we understand the practice, and there are various rules, right? A government authority or authorized representative cannot just terminate the contract on his own whims and fancy. He has to prepare a report. He has to basically provide a rationale as to why he would want to terminate the contract, even if he wants to do so. So, given these kind of mitigations, you can accept these certain clauses, right, in a government contract. So first exercise that you do is this, understand which are the risks that you can digest and the clauses where you want to definitely go back and push. And once you have identified these particular clauses, then you engage with the customer to make them understand that these are certain clauses. Help us to do at least certain few modifications that will take us forward to the closure. And apart from doing an early engagement, providing them with use cases, doing a complete round of negotiations, I don't see what else can you do to, you know, there are certain contracts which actually do not close because of these reasons. What else can you do to convince the government? This is more of a company, then it becomes like a business risk and a call from the senior management whether they want to go ahead or not. But these days, in my experience, I would say, uh, you know, we have very rational authorities in place. I have had like both. I've been on the one side of the spectrum where I had the chance to sit with extremely well-educated government authorities who were ready to listen to my valid points and have made the changes even before the contract has been signed, like which is an RFP, which is for everybody. So
I think that is the benefit of working in the tech sector, that you get to work with the better bureaucrats, perhaps.
yeah, but as I
Techno,
mentioned, it's you can be at either end of the either side of the spectrum, because one is, of course, where if you get lucky, you most of the times you have these government officials who understand. But there's also been situation where I have traveled. I remember this particular deal where I've traveled all the way to Gurgaon to explain certain extremely key clauses, in a contract wherein even a limitation of liability clause was missing, and I'm talking about probably a USD 5 or 7 million deal. And after hearing me for 11 to 15 minutes, their lawyer mentioned, Madam, why are you worrying so much? We can see all these things in court if dispute arises. Why do you have to make any changes in the contract? There is a trust. So why don't we just sign the contract as it is on trust? So, so, uh, as I said, these are the situations that you will face in a government
What
deal.
did you
I
What did
took
you
out
say to that lawyer?
Ramanuj, I took out a white sheet, wrote down that contract heading, and told him, let's sign this contract here, because since there is so much of trust, we don't even need to write the terms and conditions. We can sign on a blank sheet.
How did that go down? Did that work?
I think my salesperson had to step in. He's like, I think, yeah, this is a good discussion. But yeah, they understood. So you have to be extremely patient, but when time demands, you need to be also able to push back, because you can't just accept any and every term. And all credits to also the kind of MNC that you work in, because at HP we had a very extensive system, right, where you don't have to accept any kind of bureaucracy. If the legal counsel is recommending that this is an extremely bad contract, we cannot go ahead because there are these so many important clauses which are missing, then it is taken into consideration by the senior management. And of course, they work
Right.
towards setting up the right meetings and meeting the customer and explaining them the rationale.
Yeah, yeah. So, a lot of companies face this problem that when they are working with the government sector, and this is, I am not sure how it works with MNCs, but SMEs especially face a huge problem in getting timely payment from the government, and a lot of people have gone bankrupt because of it. And unfortunately, despite IBC, like you can take every private company to the NCLT and file insolvency petitions, and that thing is sorted. But people who are working with the government still has a huge problem of unpaid dues and getting paid on time. And the government keeps fighting these cases in the court, and they have unlimited resources to fight those battles. And sometimes the arbitration terms are really unfair and all of that. So, given that, how would you advise that? How do you get your money from the government? Like, it's one big problem that people face who work with the government.
Yeah, Ramanuj, in fact, I have handled, we used to call these troubled account. In our legal team, we had this fun term called troubled account, wherever we would never get, either delayed payment or there's always a challenge in recovering payment from the government customers. So, as I think one thing which goes back is, the same thing. You need to have a good contract. You need to be able to identify these extremely key items and, ensure that these are present in clause. Um, I would like to give you an example here, which might help. So there was this. I would not take out the project name, but this was a contract with the state of Haryana that we had, and there were certain issues. There was a bit of delay in meeting the timelines, the SLAs which are provided in the agreement, and based on that, the department stopped providing us payment, and it was due for almost a year or so. And and in fact, we received a notice saying that there will be penalty because the timelines have not been met with. Of course, there was a lot of worry in the senior management because the fact that we have not received a large sum of money from the customer. B, on top of that, there's also talk about levying penalties. So how do you address the situation, right? And this is where it helps to have a clear contract, because when we analyze the contract, we broke it down to roles and responsibility of each party, ran different kind of simulations, both in terms of the required amount that was to be paid, and also whether all the required amenities, software, or hardwares, etc., have been provided by the customer or not, so that we can do our work on those specific hardware or software for further development or customization. And it so happened that we realized that there was also a delay from the customer's end, right? Because there were these particular software that was supposed to be released on XYZ date, and then only we could do a further customization. But we never got those softwares on time. And if we when we went to the contract, we had something called a savings right. Savings right is, usually wherein it is mentioned that the vendor will not be held responsible for any kind of delay or lapses if the required, if any, if the delay has happened due to, its delay is attributable or happened due to the lapse on the purchaser side, not on the vendor side. So basically, since there was a situation where where the delay has happened due to customer, we could actually retaliate and say that, look, we are not liable to pay any penalties, and in fact, whatever the due amount is, we should be paid back. So this was in a public domain, so I can of course discuss this particular instance. So yeah, just to give you an example.
Very interesting example. I'll share with you another thing, but before that, I want to ask you, what do you do in cases where there is no dispute? Nobody is disputing the amount to be paid, simply not paying up, because that's quite a majority of cases where there is no dispute. Actually, just payment is not coming through.
Yeah, so Ramanaj, what happens at, I mean, to give you a candid answer on this, practically you don't just terminate. So you of course will, but the moment there is a dispute, there are rights and obligations in a contract, right? And one of the obligation on the other party is to pay a consideration for whatever services that they are taking. The moment they don't abide by that, of course it's a default, and you have the right to terminate the contract, and of course, seek for damages, take it into, probably file a payment recovery case, etc. But in instances where you're dealing with government customers, it doesn't immediately go to that situation, because the delay at government end is due to various reasons. It might be so that you will be surprised, but I have seen situations where there has been a change in department, the members of the department, and hence the other person was not aware that
Yeah.
these are the payment which needs to be released, and the payment is on hold for almost 6 months. So, yeah, sorry, you were saying something?
I was just saying that sometimes the government officials would try to release all the payments before going, because if once they're gone, nobody knows when the payment will come through.
I wish that, every MNC or every vendor is, does have government customers like these who release payments in advance. I wish that was a situation. But yes, I mean, this is a scenario that, at a practical level, you just don't go ahead and terminate the contract immediately. Of course, you try to solve it at a relationship level first. The management people of both end coordinate or interact with each other to release the payment. But if it, even after a good amount of time has passed and you have not received the payment, then definitely you can analyze the contract, understand what is your, rights under the contract. More, as I mentioned earlier, termination is one of the avenues, and also you can seek damages, or if there is any other such right that is levied, such as late payment interest. So then you can work with your lawyers to file a litigation, of course, which is a time consuming and a cost for the company. So the best situation would be to avoid, but if you cannot, you aren't left with any choice.
Right. So interestingly, one very common dispute that we see, and this is interestingly one of the exercises we have in one of our courses. This is about basically the hypothetical situation is that there is a defense contract,
Mm-hmm.
and you are providing certain technological equipment to the government. And after that, how do you know when the performance has been done? Like, what clause are you going to include in your contract, or what mechanism you're going to provide for to be sure that the performance is complete. Because what often happens is that government keeps coming back to and asking for more and more. In fact, there is a term in defense contracts which calls over and above services. So I mean, it's a parlance that in the defense with over and above services, which means that they'll be calling you to repair things or things that they have broken, or there may be a power issue because of which your equipment got damaged, and they will say that under the contract you're required to replace this, and the performance is never complete. I mean, it goes on and on till they say it is not complete. So we asked them to create a mechanism where it will get complete. Like so there is a certain form that has to be filled at a certain point during the performance, which just actually notes down what has been delivered, what has been accepted by the other party. So I mean, what could be some possible methods that can be used in a circumstance like this?
Yeah, on the cost of sounding too technical, I think the clause that you explained was acceptance clause. So this is a classic, this is a classic example of a government contract, Ramanuj, which usually in most of the tenders we see situations like this. So the most important thing you need to understand is the timeline. So whoever is the assigned counsel needs to first understand the solution and understand the kind of products which is being delivered. Is it like a product which will be delivered over a, let's say, like a 2 year period or a 3 year period, or is it like a product which will be delivered one time, right? Like today you are just going and probably providing these X amount of arms, let's say, in case of a defense contract to them, right? So first, to understand what's the product and what's the quantity of the product that you're providing, and over a what period of time. Based on this period of time, you need to definitely chalk out milestones, or like a timeline sheet wherein it mentions that, let's say 10 products will be delivered by, let's say, 31st of July, right? And once it is delivered, the process is that there is something called as acceptance form, which you just mentioned. So usually the receiving party has some time to inspect that product and understand if it meets their requirement and specifications as was mentioned in the RFP. For a government contract, it ranges anywhere between 30 days to, like, anywhere between 15 to 30 days, or it might be more depending on the kind of product and services. And once that acceptance is done, acceptance is always done through a form wherein they will have to acknowledge receiving of these X number of products. And of course, these are all documented and then it is provided. Uh, from the aspect of what you were saying is that if something happens, then it gets repaired and they have to replace it, and that continues. What actually we're talking about is a classic case of evergreen warranty. Now, in like many government contracts, what they try to, it's a very smart move. What they try to do is, they will tell you that there is no specific warranty. Apart from that original equipment manufacturer, that warranty, let's say he has given a 1 year, what government asks you is that, you also provide me not 1 year warranty, but you provide me an extended warranty of, let's say, 5 years. So you need to understand whether there is any kind of an additional support that you're taking from that original equipment manufacturer, like, which is one plus maybe 4 years of support cost that you would have paid, and you're factoring in your final bill to the customer. And if not, then be very clear that you have terms, or like, you have clauses which very clearly depict that the products will be provided as per the specific OEM warranties. Okay, and there's no additional warranty that is being provided. So these are the ways that you can mitigate yourself, and for any additional product that they might want to take from you, there is something called as change order. This is a very standard process. Ensure that you have a change order or a change management clause in your contract, which allows the customer, especially in case of government customers, to procure additional equipments or additional products and services based on the same terms and conditions. And sometimes there might be a same price as well for a fixed duration. It helps to reinvent the wheel, I get into again new negotiations, or for the government to again float new RFPs. I hope that makes sense. I know it's a bit technical.
Yeah, absolutely. Great. So, government contracts are definitely very difficult to handle, but you have given us a lot of insights today and a sense of what kind of work is done. And thank you so much. We would be ending our discussions here, but before we go, what would be your final message to all our viewers and listeners?
Uh, I mean, there's no particular thing that I would want to say. In terms of becoming a technology lawyer, if that's what you aspire, just ensure that you have that clarity. Work towards creating a resume or working with the brands that help you to grow further in that domain. Pay attention to details, which is very important. Whether you're a technology lawyer or a law firm lawyer, and just enjoy your work. Till you enjoy being a lawyer, I think yes, you will enjoy your work anywhere, be it in house or at a law firm.
Great. Thank you so much. It was a very enlightening session. We have learned a lot today, and we hope to have you back one of these days talking more about these things. I mean, 1 hour and a few minutes is very less time to learn about the so much years of experience that you have and a lot of different laws that we can talk about. We hope to back you again soon one another day. And thank you so much for taking out time for an hour with LawSikho. And all those who have been watching, thank you so much for joining us. Tomorrow, 9 p.m. every weekday, we have an hour with LawSikho. So definitely join us back again for another interesting session tomorrow. And do subscribe so you don't miss the videos, and if you cannot watch them live. And thank you so much, everybody, and good night. Hope to see you tomorrow again. Bye, everyone.
Thank you so